Good afternoon, everybody. This is Mubarak. Thank you for tuning in. We are just going to get started here shortly for this week's update from our Mubarak law offices in Orlando. So today we do have Attorney Joel Caminero joining us, and we have a special topic of ICE detainers, bonds, deportation, and what defenses do we have. We are also live on Instagram today, so you may see me going back and forth on the two cameras, but thank you guys for tuning in. So we'll just wait a few more minutes. We will be taking several questions today as well. This topic does tend to get a lot of questions, so please feel free to comment, like, subscribe, or share with anybody who might need this information. As today we're going to discuss the removal proceedings process, which is more commonly known as deportation, and also an ICE hold after somebody's been arrested, for example. But before we get started, we do have some basic things to address. So yesterday, obviously, the governor introduced phase 1 of reopening Florida. So I thought I would just share some things with you, such as restaurants are going to be at 25% capacity. The outside seating is going to be allowed as long as restaurants have tables that are 6 feet apart. Unfortunately, schools are not going back to normal yet. They will continue with the virtual online learning. Barbershops, gyms, all of these are still subject to the government shutdown. So, excuse me, not government shutdown, the Florida shutdown for the pandemic for all of our safety. The governor says once they have additional information on the statistics, there will be a phase 2. But for now, phase 1 starts on Monday, May 4th. The curfew for 11 o'clock is still in effect, and there are $500 fines for those who do violate. As I mentioned today, Attorney Joel and I are going to discuss deportation, defense, detention, and ICE bonds, how to get somebody out. So if you're just joining us, I think this will be an interesting topic. Even if you are a citizen and this will never affect you, I think learning about this process is very interesting. What we do here is every week we are providing you guys with different updates on different areas of the law. So today, let's go ahead and talk about deportation. But before we do, we're going to share some good news, as is tradition here. Tomorrow, the AACC, the Arab American Community Center of Central Florida, is providing meals for Central Florida who are hurting during this difficult economic time, and for those who are participating in Ramadan. Mubarak Law, we are happy to sponsor. We are, going to help hand out some of those meals tomorrow. So that is something that we are looking forward to. Tomorrow is also May 1st. It's going to be May, and we are out of April. And then we issue our weekly or monthly newsletter, rather. So if you would like to be added to our newsletter, please let us know. And without further ado, I'm going to bring in Joel. And Joel is going to talk to us about detention, bonds, removal, and deportation defense. So Joel, why don't you tell everybody really quick, first and foremost, what is a ICE detainer or an ICE hold?
Hey, good afternoon, everyone. My name is Joel Caminero. Just to start it off, we are going to discuss what is a detainer. A detainer is basically a request that ICE would submit to the local law enforcement jail, requesting that a non-citizen individual be held, if they are otherwise released for 48 hours. What does that mean? It basically means, for example, once a bond is paid, ICE will be informed that a bond is paid or has been paid, and that individual will be held for up to 48 hours. Generally speaking, they have up to 48 hours to pick them up, ICE does, but it's not uncommon for an individual to be held longer than that.
So I'm just going to repeat what Joel mentioned for those who are joining us on Instagram. So an ICE detainer is for non-citizens. It notifies the federal government that there is a foreign national who is detained, and ICE can then come interview the individual or determine whether or not they should be released. So even if you are a green card holder, this is very important. You can be subject to a detainer. So again, if you're just tuning in, we are talking about somebody being arrested and then you go to pay their bond and they're subject to what's called an ICE or federal hold. So Joel, are only citizens protected, or who else would be subject to any type of ICE detainer in addition to, green card holders?
Right, just any non-citizen, whether you're here on a J, an F, an M, an H, even a tourist visa, you could be detained if you commit certain criminal acts.
So if you're not a citizen and you get arrested, ICE can definitely come interview you. Some offenses are what's called, removable offenses, or if you have previous criminal history, you can then be subject to removal proceedings. And we'll get into that later. So if you're here on a student visa or a tourist visa and you get arrested for anything minor, it's very possible and more likely than not, you will be getting a visit from an ICE agent. Now, a lot of times at this stage, when the family has already paid the criminal bond, they'll call us and say, hey, why isn't my family member getting out? Why is my cousin still in there? What is this federal hold? What is this ICE hold? So it's really important that you speak to a bondsman, especially if you know, or an attorney, really, especially if you know the individual arrested is not a U.S. citizen, because you need to be able to plan it out on whether or not you should be paying the state bond or if you should be trying to release or lift the hold. So, Joel, what can somebody do if they find a detainer on their individual? What can they do as an individual?
I mean, our recommendation as an immigration attorney would be to not pay the bond until you've spoken with an immigration attorney specifically. A lot of criminal defense attorneys aren't aware of immigration consequences. Oftentimes, if ICE does take them into custody, the individual will lose an opportunity to dispose of their case in the criminal matter, for example. And if they are taken into ICE custody and placed in a detention center, the likelihood that they will be brought back to the local court to deal with that is extremely rare. And it's unlikely that they will dispose of that charge. Oftentimes, an individual is issued a warrant for their arrest for failing to appear because they're being detained, and ICE does not communicate that with the local court.
So that's a really important point. So even though you've been arrested, you have a state charge pending against you. You now have immigration charges pending against you. They're not going to communicate with each other and say, well, I have John Smith in immigration custody. This is why he's not at state court. So it's really important that, you're going to have to lawyer up with a criminal defense attorney and also work with your immigration attorney. And Joel, if somebody has an immigration hold on listed against them, are they for sure going to immigration custody? Is there any way to have this immigration hold lifted?
I would say that once the hold is placed, it basically depends on how the individual would become releasable. Either their case was disposed or a bond was paid. But the likelihood that ICE will take them into custody is very high, especially within this administration. And it makes things a lot more difficult to defend someone's immigration matter once they're transported, because we have to get documents signed, evidence corroborated. And it's a lot easier for us if the individual is at the local county jail as opposed to a detention center.
And on our website, we have frequently asked questions that you can go to for your reference. So if you want to know what should we do or what does it mean when somebody has these, please check our website for this. So Joel mentioned a really critical point. We need to have the foreign national or the non-citizen sign a representation document that allows us to communicate and represent them with ICE. If they get transferred to an immigration facility that's 5, 6, 7 hours away, either you or your family are going to have to drive out there to get a signature, or you're going to have to retain an attorney to get over there. And in addition to time and expense being lost, a lot of times it's better when we can gear up and get the evidence and speak to your family member or friend to ask where specific documents are. This way we can help prepare the motion for bond more quickly and try to limit the amount of time somebody is going to be in detention. So that kind of segues into my next question. So again, some people have just tuned in and we are discussing immigration deportation proceedings, or properly known as removal proceedings, bonds, and ICE detainers. So let's say, Joel, we've tried to speak to the ICE agent. They're not going to lift the hold. Family has paid the state or local bond, and now this individual is being transferred. Is there any way to know where they're being transferred to?
This is it's a good question. It's important that the family member or loved one has information on the non-citizen, such as their A number. If they don't have an A number, which is basically the equivalent of a social security number, kind of, it's just a number that references the alien. If you don't have that information, you would need their full name, date of birth, and country of origin. And you can do an online detainee locator search. And I think we have the link as well that we work
with. Yeah, I'll share the link here.
Right. There's definitely there's at least, well, there's 4 potential detention facilities in Florida. There's Glades in Moorhaven. There's Broward Transitional Center. There's Chrome in South Florida, and there's Baker County near Jacksonville as well. But it's not uncommon, it's not rare for individuals to be transported out of state, such as detention centers in Georgia, Folkestone, Atlanta, and the Stewart Detention Center.
So just to recap, if the individual is going to be transferred, it's hard to tell where they're going. Oftentimes, we can't even locate them until they've reached the facility and have been processed for several hours. The benefit of having an attorney is if you reach out to the ICE agent, oftentimes they may communicate with us where they are heading. So this is nice to give the family time to prepare and some ease to know that their family member is okay, because it is scary for a lot of people when you can't locate the family member and they're just not in the system. So the ICE detainee locator is not going to work unless you have very specific information, unless you know their A number, their date of birth, and country of national origin. Anybody who's not a citizen of the United States, I recommend you need to have somebody who has access to your files. And this can be, just a scanned copy of your visa, a scanned copy of your passport, any birth certificate or marriage certificate. You always need to prepare for a day that may be inevitable. I mean, you may get pulled over for running a red light, or your tag is expired and you have no idea about it, and there could be, an outstanding issue. So you always need to be prepared. You should have copies of your documents electronically filed with somebody or a family member, so that way that we can better assist you. Now,
nowadays, it's also good to just use the cloud, any cloud-based service, and share it with family members or friends and family. It's a good way just to be ready for things.
And this kind of can save you days. If you're in a detention facility, it can take 2 or 3 weeks before you have a bond hearing in front of a judge who's going to release you or grant your bond redetermination request. So, but if your family members are spending 3 or 4 days looking for documents for us, then that means those are 3 or 4 days longer you're going to be incarcerated. Now, that doesn't sound like a long time, but if you're inside a detention facility, 3 or 4 days is a very long time. So you want to be prepared for this. You want to make sure your family members have this. So Joel mentioned several detention centers in Florida, in Central Florida. We have Baker County. South Florida has Glades, Broward, and Chrome. What court hearings do we hear in Orlando, Joel?
Typically, it's Baker County. Anyone detained in Baker County will appear by video teleconference at the immigration court in Orlando. Those that are in Glades get transported to Chrome. The Chrome Detention Center has its own built-in court. I think last I checked, there's 4 judges there. And the Broward Transitional Center also has its own built-in court with 2 immigration judges. So we would have to travel there or do a telephonic appearance if individuals are in those centers.
Okay. So they're now in the detention facility. What happens next? What happens to this individual? Are they charged with anything? What is the process behind this detention?
Right. So timing is definitely crucial. If they haven't been there long, and by long I say within 48 hours, it allows us, we have an ability to connect and communicate with the detention and deportation officer that's assigned to the case. And I wouldn't call it negotiating, but we would inform the detention and deportation officers that these individuals have a form of relief at least. And relief means a way to fix their status. and they're eligible for bond. So we would request first from ICE for them to be released on their own recognizance or a low bond. This can be done before they appear before an immigration judge. If ICE declines to release the individual, they would have to file the notice to appear, which is the charging instrument for immigration court. They would file it with the immigration court. And once that happens, they pretty much leave it up to the immigration judge. At that point, only the immigration judge would have jurisdiction for custody redetermination. So it's very crucial to contact the detention deportation officer.
So when the immigration removal proceedings are initiated, or once the person is taken into custody, they're going to be served with a charging document. And this is going to be called the notice to appear. And this will have the allegations or the accusations that say, you're not a citizen of the United States. You are a citizen of X country. You arrived here on this date, or you are fell out of status on this date, or you are being charged as removable or inadmissible for the following reasons. And so these are what we call charges, right? And a lot of times that's going to equate as close as possible to criminal charges as to why you're in front of the judge in the first place. And Joel mentioned a very important word, which we call immigration relief. And immigration relief is basically like defense. How do we defend your case? Deportation defenses. There's all sorts of different options, like cancellation of removal for permanent residents, or cancellation of removal for non-permanent residents. You know, this is also known as like the 10-year visa in many communities, but that's not the proper name. It's cancellation of removal for non-residents. So this is where this individual's proceedings are going to be taking place. And there are two types of proceedings. There's going to be removal proceedings and bond proceedings. Joel, can you tell us the difference between them?
Right. So to avoid a technical explanation, I guess it's two separate hearings. You're right. The bond hearing is a separate matter from the actual removal proceeding. So the judge typically does the bond hearing first, in my experience, and they just go through eligibility for a bond. Oftentimes, they also want to see what forms of relief is available for this individual. They're really focusing on that now. Generally, to qualify for bond, you have to show that you're not a flight risk, which means you're going to come back to court, and that you're not a danger to the community, which means if you are released, you're not going to go do whatever, ended you up in there. But those are typically the things that would occur at the bond hearing. An attorney would advocate and argue that you are eligible for bond and you're going to come back to court and you have a stable residence, whether you're employed or not. We have to document and show the judge through evidence that you are, someone worthy of a bond.
Right. So Joel mentioned, Attorney Caminero said, when we want to go for bond, what are we going to prove? This person is not a danger to the community. This person is not a flight risk. And now what's become really important is what type of relief is this individual seeking? So the judges want to know, does he have any options here? So immigration law is pretty clear as to whether or not you can even apply for a certain relief or defense. And then ultimately, if you don't qualify for relief or defense, you don't even really ever have a formal hearing because there's really no option available for you. So it's really important that you have an experienced attorney look at your charges, look at your history, and see maybe there was a law change before 2001. Maybe there was a previous application that you submitted, and this is all so critical in defending an individual. Let me see here.
Right, and I did say that bond and removal proceedings are separate, which they are, but sometimes it's better to do the removal process, which lets us plea out your case. Essentially, sometimes we would have to deny certain allegations or contest certain charges before you become bond eligible. For example, if you're charged with certain crimes that subject you to mandatory detention, then it would make no sense to ask for a bond. You only have one chance, one request for a bond, and if it's denied, it's very difficult to get a redetermination before a court.
So we are, discussing all of these next steps. Now, if the individual successfully gets out, let's assume gets a bond, Are there deportation proceedings or removal proceedings? Have they terminated? What's next for this person?
Right. So if an individual is granted a bond, that means the judge has accepted that you're not a danger and you're not a flight risk, and the judge has likely made up his mind that you have at least some type of way to possibly fix your status through relief. So as soon as you're released, you always have to keep the court updated with your addresses, because if you get a subsequent notice of hearing, basically telling you this is the date you have to come back to court, and it's sent to a wrong address, you could have an order of in absentia, which basically the judge can order you removed if you don't show up to that hearing. That's one thing you should keep in mind. Always keep the court informed of your address. But yes, that will give you an opportunity to speak with an immigration attorney as well, to discuss what forms of relief you qualify for, or what removal defenses to deportation we can pursue on your behalf.
And that's such an important point with the making sure you change your address. More importantly, if you're charged with a notice to appear, or the proceedings are initiated, more likely than not, you are signing a document that you've been served with these. You sign the document saying that you've been served and you've been given notice. We've seen mistakes on the address where the officer, made a typo, where the officer didn't include an apartment. Then the client never gets the notice. So guess what? To no fault of your own, you're not getting the court notice. Now you have a deportation order against you, and you won't even have a right to see a judge, albeit minus some extraordinary circumstances. But when you sign the notice to appear, you want to request a hearing to see a judge, unless you absolutely know that you don't want to be here anymore. But you have a right to see a judge. You have to request it on that form, and you have to double check your address. So you might be going through a lot of stress at the moment when you receive this document from an ICE agent, and this is for non-detained or detained or not. And you need to make sure that your address is correct, because when you sign that document, you're basically saying that all the information on there is correct. So if they send it to the wrong house, they'll just say, well, he reviewed these addresses. He should have been in court. So I really appreciate Joel sharing that information with us. So, Joel, what else would you advise for people in removal proceedings? So we are talking about deportation and removal defense. Is there a trial? Is there a jury? How is somebody decided on whether or not they can stay here in the United States?
Right. So all removal proceedings end with what's called an individual merits hearing. Basically, that's the trial. It's not a jury trial. It's basically the judge. He's the one, or she's the one, that's going to either grant or deny relief. The prosecutor in that matter would be an attorney for the Department of Homeland Security, working through the Office of Chief Counsel. So that's basically the prosecuting entity. But yeah, it's very tough right now, because both the judge falls under the Department of Justice, and the prosecutor falls under the Department of Homeland Security, which are both under an executive branch of the president. So
these aren't, circuit courts. These are administrative agency courts. So the Department of Justice that Joel mentioned is an agency. And so this is how, there is not going to be a trial by peers. The judge will make a determination about the eligibility and whether or not this person qualifies for relief. As we mentioned, like this immigration hearing that Joel mentioned, individual hearing, this is what we consider like a trial, right? But if you don't meet certain requirements, or if we can't prove to the judge that you meet all the requirements to apply for this defense or apply for this relief, then you'll never really have that final hearing, because you either qualify or you don't, and then the judge makes the decision to grant your application. So even in deportation, even in courts, you have applications pending, and the judge makes the decision ultimately to whether or not determine if you should be granted relief, ordered removed, which is known as deportation, or voluntary departure. Joel, what is a voluntary departure?
Voluntary departure is essentially when it's negotiated oftentimes, but the judge, if the judge grants you voluntary departure, you have a set time frame to leave the country and avoid an order of deportation, which could help some individuals in some cases, especially if you have a manner of regaining lawful entry. A lot of individuals that have a pending family petition would choose to get the voluntary departure rather than be ordered removed and go back to their country while the petition is being processed. It would avoid certain waivers for sure, and it would make your ability to re-enter the country once you have the approved petition much easier.
Right. But if you need to be honest with your attorney, if you are not going to leave, if you're not going to voluntarily depart, this is not a better option for you. This can, that's viewed as discretionary relief from the immigration judge. They're doing you a favor to let you leave on your own terms with voluntary departure. We call it VD. If you don't leave, you can be doing more harm for yourself than anything else. So it can be beneficial in some ways, and it cannot be beneficial in some way. If you've been here undocumented for over a year, you take voluntary departure, yes, you don't have a deportation order, but then you will have be subject to a 10-year bar for unlawful presence in the United States. So I've seen it too many times where somebody thinks like a voluntary departure sounds good. I left voluntarily. They don't know that there are all sorts of consequences in addition to the removal proceedings that can happen against you. So again, it's not even a question. If you're in removal proceedings, you need an attorney. And then you need to make sure that they have evaluated all forms of relief and all consequences of your entire history. So one really needs a full background on when you came to this country, what applications you've applied for, because this can really open up different options for relief or defenses.
Right, and I just want to make a quick point about voluntary departure. You can get voluntary departure while you're detained or not detained. And I've seen many people that are detained accept voluntary departure, thinking that they will be released back into the general public. And that's absolutely not the case. In rare circumstances, maybe, but in the most cases, you will be either sent to a different staging area, typically maybe Louisiana, and be placed on an aircraft and sent back home. But oftentimes people do take voluntary departure because either they're misadvised or they don't understand the way it works correctly.
So we do have some updates on the courts right now. So in addition to the governor's plan to reopening Florida, USCIS won't have any interviews in person or in-person appointments until June 4th. Immigration courts for now are scheduled to reopen for May 15th. This may or may not change. And then the circuit courts, for example, again, are June 1st. So if you have any pending matters, you need to definitely reach out to your representative to determine when your next hearing may be. So although these agencies are not doing in-person interviews, they are still working on applications, and we are filing, citizenship applications or investor visa renewals because those agencies are still working. They are at a shorter staff, and the courts are working on detained only. But just to give you guys a quick update, because I know there's a lot of confusion, is my application pending or is it not? Can I apply or what's going on? So that's what we have for you today on updates. And Joelle, is there anything else you want to add about immigration, detention, deportation, or bonds?
I just want to reemphasize how important it is to communicate with an immigration attorney before anyone pays the bonds for a non-citizen individual. It could be extremely crucial to the outcome of their case.
Okay. So if you have any questions, again, or you found that this information was valuable, please feel free to contact us. We will continue to do these weekly updates for you all. And, we've already covered citizenship, the public charge rule, the travel ban, deportation defenses today, and detention. So then next week, we'll keep you posted on the latest changes in the law and other areas of law that we handle. So if you have any questions or recommendations or suggestions on a topic you'd like to learn more about, please let us know. Subscribe to us on Facebook and all the social media platforms. As mentioned before, we always do the fastest updates possible through social media because we can reach a wide public at that time. So I don't have anything further. I will post for you guys this link one last time if you're looking for an individual. it's also on our website. So on the FAQs portion of removal and detention, you can find this link. Again, you'll need the A number, your date of birth, or their country of origin in order to access or locate a specific individual. All right, well, thank you guys for tuning in. I don't have anything further for you. And Joelle, thank you for all the information. It's always a pleasure. We are operating at Mubarak Law. We, have been working on all of our cases and just here if you guys need us for anything. So feel free to reach out to us by phone or email. All right, I hope everybody has a great day, and thank you for tuning in.